Free audio post-production by alphonic.com.
Hi everyone, welcome to Stone Slow again with Salamatu. And today we are going to be talking about the law of agency and commercial law. In the business world, companies and even sole entrepreneurs work with agents who act as some sort of middlemen for these businessmen in their dealings with third parties or strangers. These middlemen are the people we refer to as agents, with some sort of authority given to them by these businessmen, whom we call principals, to transact businesses and to make dealings within the business world on their behalf. Agents are crucial in the business world because of the need for businessmen to delegate some of their functions and for there to be division of labor, which is essential for the smooth running of businesses. The law of agency, therefore, is the law that regulates the creation of the agency relationship and determines the scope of the agent's authority. Ideally, it should have been the businessman who deals directly with these third parties. And so, for example, if this businessman is into the sale of goods, then he must be the one to procure the goods and then be the one to come and sell them. But in reality, most of the time, the businessman may not be the one who goes to buy them. He may buy them through someone, or he may send someone to buy them. This person who acts on the instructions of the businessman to go and purchase these goods or to even sell them on behalf of this businessman is whom we call an agent. And so the entire concept of agency alters the natural course of business dealings. What a businessman should have done himself, he does it through someone. And that raises questions as to the extent of the liability of the businessman, whom is the principal in this case, and even the extent of the liability of the agent, the extent of the authority of the agent, and the extent of the powers of the principal. A case that explains the concept of agency is the case of Japan Motors Trading Company Limited versus Williams, in which case the plaintiff bought a motor vehicle, and when the vehicle broke down, he contacted the defendants to provide spare parts for the vehicle. Defendants informed their suppliers who were out of the country to provide them with the spare parts. Now, there was some form of miscommunication. The international suppliers thought that the purchase was going to be in bulk, but it turned out it was just for one vehicle. And so when they found out, they tried to pull out of the entire agreement. At the time, plaintiff had already paid for the spare parts. And so when the spare parts were not forthcoming, he decided to sue. Now, the court has to determine an issue as to agency, and in doing that, distinguish between who an agent is and who a seller is. Because when a supplier agrees to provide goods, he is doing it in either one of two capacities. It's either he's doing it as an agent of the person who requested for the goods, or he's doing it as a seller of the goods. Now, when he's an agent, he does not procure the goods at his own cost. He would have merely agreed to fulfill the order by due diligence. And he usually would not have been the one who provided the funds to buy the goods. The principal would have been the one who provided them. Additionally, he would have contracted to supply the goods in his capacity as an agent in exchange for some sort of commission for the due fulfillment of the order. On the other hand, when he agrees to supply the goods in his capacity as a seller, he is agreeing to provide the goods at his own cost and would usually quote a price for the buyer/businessman who would have requested for the goods. And so that is the difference between the two of them. One word describes the entire concept of agency, authority. As I mentioned, the agent is doing what the principal would have done if he had gone on the errand himself. And so the principal is transferring his authority to the agent, and the agent is bound by the scope of that authority. The nature of the authority given would determine the type of agency created, and we'll be discussing four of them. But first, we must understand that the court is not as concerned about the labels and designations used by the agents and the principal in describing the relationship that exists between them, as it is about what the authority actually denotes. So even if the parties don't describe the relationship between them as an agent-principal relationship, but there is evidence to suggest that the agent was at all times acting in that capacity, then the court would recognize the relationship as an agency relationship. In Asare Original Payor versus Bafo, the court said that it will look to the intention of the parties in determining not only whether or not there was an agency relationship, but also the kind of agency relationship that arose. As a result, the conferment of authority on any person, for which reason we can say that there is an agency relationship between that person and the person that conferred the authority, could be express or even implied, depending on the circumstances. The first type of agency we'll talk about is agency by agreement, which confers actual authority. Like the name suggests, this type of agency arises out of an agreement, whether express or implied. So there can be express actual authority and implied actual authority. So in this kind, there's always some sort of agreement, some sort of contract that is evidencing the formation of the relationship. There is some document you can point to that shows that the parties, principal and agent, agreed to enter into an agency relationship. But even when there is no such written contract, we know from our contract law class that a contract can exist even if there is no writing to support it. And so it's the same thing over here. Even if there is no writing evidencing that the parties agreed to start an agency relationship, the court will imply that there is such an agreement having regard to the facts and the circumstances surrounding the formation of the relationship. But then again, the court cannot imply that there has been an agency relationship if the relationship or the facts surrounding the relationship between the parties does not align with the general principles of agency. And a case in point is the case of Lamb versus Goring Brick Company, which is an English case in 1932, in which case the defendants were brick manufacturers and they appointed the plaintiffs as their sole selling agents. But part of the agreement was that the plaintiffs were supposed to pay the defendants a 10% discount of all the goods that they received from them, regardless of whether or not the goods were sold. The court said that there can be no agency relationship because in an agency relationship, an agent will not be expected to have that obligation. And so the contract was only a contract of sale and does not give rise to an agency relationship. So you see that in this case, there is a contract that specifically states that there is an agency relationship or an agency relationship has been created. But then having evaluated the contract, the court concluded that there was no such relationship, and so it didn't confer actual authority because it does not conform to the principles of agency relationships. As I mentioned earlier, it does not matter what the parties have agreed upon. Even if there is an actual contract, the court will go ahead and evaluate it and see if it conforms with the principles of agency. And if it does not, it cannot to have created an agency relationship at all, and therefore cannot even confirm actual authority. In another case, a Ghanaian case, Hoebi and Sons versus Daniel Jima, the plaintiff's case was that there was an oral agreement making him an agent. The defendants denied it. But that in itself was not a problem. The absence of a written agreement was not the problem. As we've said, if the courts can evaluate the facts and circumstances to mean that there was some sort of agreement, even if it wasn't in writing, then the court will go ahead and hold that there has been an agency by agreement, which then confers an actual authority. But then in this case, the court held that there was no agency relationship. In other words, the plaintiff was not an agent of the defendant because not only was there no written evidence to show that they had agreed to appoint him as their agent, the facts and the circumstances of the case do not support the creation of an agency relationship by implication even. So there was no actual authority, neither was there actual implied authority conferred by way of an implied agency agreement. And so agency by agreement or the creation of an agency by agreement is simply that there was an agreement, whether express or implied. The second category of agency relationship is agency by estoppel, which confers what we call ostensible authority or apparent authority. This type of agency arises where a person, the principal here, has acted in a way that gives this other person, the agent, the impression to reasonably believe that he has been appointed an agent or he has been authorized to do certain acts in his capacity as an agent. And with the knowledge we have from contract law with regards to how estoppels work, the belief has to be reasonable. And it has to have been caused by either the actions or the words of the principal. And this belief is shared by especially not just the agent, but also even the third party. So in other words, not only did you act in a way that gives somebody an impression that they can enter into certain transactions on your behalf as your agent, but you caused even the people who are on the other side of the transaction, the third parties in this case, to believe that this person is your agent or can act as such. In that case, then equity prevents you from now coming back to deny the liability that arises out of the person having acted as your agent. And like I mentioned, this type of agency by estoppel confers ostensible or apparent authority. And like the name suggests, you can see that it is not actual, but then we are implying it, not even because there's some sort of agreement that can be gleaned from the facts or circumstances, but because you have acted in a way that gives that impression. And a reasonable person would have believed that that is what you were trying to communicate by your actions and by your conduct. So the person's authority is not actual, it is ostensible or apparent, arising out of your conduct. A case in point is the case of Ada Cooperative Farmers versus Abode, in which case the courts restated the definition for agency by estoppel as found in the third edition of Halsbury's Laws of England. That agency by estoppel arises where one person has so acted as to lead another person to believe that he has authorized a third person to act on its behalf. And that other person in such belief has entered into transactions with the third person within the scope of such ostensible authority. And so this definition even emphasizes the need for the person at the other end of the transaction to have believed that this agent was acting on behalf of the principal based on the principal's own conduct. And like I said, conduct includes words and any other thing that a court can look at to say that you actually, by doing these things, gave this person the impression or gave this person on the other side of the transaction the impression that this person, this other person is your agent, and he was justified in taking it as such. And so now you would be liable for whatever decisions that this agent of yours made because you conferred authority on him, albeit it's not actual but apparent. In Rama Corporation versus Prooftin and General Investments, the court identified 3 elements needed to establish the existence of ostensible authority, for that matter, agency by estoppel. The first one, that there has been a representation, and for the purposes of our discussion of agency, that representation ought to have been that such a person was your agent or such a person was the agent of the principal. Secondly, this third party must have relied on the representation. And 3, he must have acted to his own detriment. So he must have acted on the basis of that representation. And in the process of doing that, his position ought to have been altered as a result of it. For example, he entered into a transaction because he thought he was dealing with the agent of this principal, and that he maybe gave out monies or he made some payments thinking that this person was the principal's agent and all of that. So he must have acted on that representation to his own detriment. The third type of agency is what we call agency by operation of law. And this arises in situations where the agent is not able to get the authorization of its principal. But in order to save the principal or to do something in furtherance of the interest of the principal, he goes ahead to make a decision, and now there has been some sort of liability. The law is that in such an instance, the principal will still be liable for the decisions that the agent made in those circumstances because he couldn't get the instructions of his principal. This is not a case of a busybody going to meddle in the affairs of someone and then turning around to say that that person should be liable for his actions because he was acting to save this person. No, it's not a case of that. It arises where this person is already an agent of the principal in one way or another, either expressly or impliedly. But you know that because agency has to do with authority, then the agency agreements would have some sort of delimitation. So the authority has been delimited. But that particular situation is not captured in his area of authority. But he needs to act fast. He's in a situation where he has to make a decision that would affect his principal in one way or another. And that particular decision that he has to make is not within his area of authorization. What does this person do? Does he sit down and watch as his master's business get destroyed? So in such an instance, when he makes a decision and it ends up coming with some sort of liabilities, the master would be bound by it, regardless of the fact that it falls outside of the scope of his authority. An important case is the case of Madame Efua Mensah versus the developer. Madame Efua Mensah owned land and she realized that somebody was developing the land, but she couldn't identify who the person was. Hence the term the developer. She instituted an action in court seeking to recover possession. The processes were served by substitution by posting them on the premises because she couldn't find who was actually developing the land. The defendant did not enter appearance, and so judgment was entered in default of appearance. She enforced her judgment and caused the building on the land to be pulled down. It was only then that one Madame Serasaki would come and say that the land belonged to her and that the developer in the case was really somebody she had put on the land to build on the land for her. She now said that at no particular time did the processes come to her attention, and that was why she could not enter appearance to defend the action. The court said that in that particular case, the developer was her agent because she had put him on her land. And so as her agent, he had been served by substitution, i.e. by posting those processes on the walls of the building. And so he saw them, or he had been served. And so once he had been served as her agent, it meant that she had also been served. Now, like I said, whatever she puts the developer on the land to do does not include receiving court processes. But remember, we are discussing agency by operation of law or by result of necessity. And so the court said that this was one of those situations where by reason of an emergency, somebody who is already an agent but whose authority did not extend to certain areas can be said to have authority to make decisions in regards to those areas because there is an emergency. In Menu versus Kuma and also in Hayford versus Moses, it was established that for an agency by necessity or agency by operation of law to be created, there had to be three conditions. One, that it was impossible under the circumstances for the agent to get the permission or to get the authorization of the principal. Secondly, that the agent's action is necessary under the circumstances to prevent loss to the principal. And then thirdly, that the agent acted in good faith. Once these conditions are met, then the law will protect the agent from any liability. And it would, in fact, compel the principal to bear the resultant liability. The final category of agency we'll discuss is agency by ratification. And in this case, the agent had no authority to act. But then after he had acted, the principal decides to ratify the action of the agent. In that case, he's saying that you didn't have authority to act, but then I'm going to go ahead and bear liability for your actions. And so it doesn't exactly confer any form of authority, because at the time the person made the decision, he didn't have authority. And at the time that the principal decided to bear the liability, he's only doing it in retrospect after the act has already been done. By way of a summary, all that we've discussed is simply who an agent is. We said that an agent is someone that another person called the principal has contracted to deal with third parties on behalf of that principal. This agent would have authority conferred by the principal to enter certain transactions and make certain decisions, which the principal will then be bound by in law. We also discussed the 4 categories of agency relationships. We said that 1, there is agency by agreement, which confers actual authority on the agent. And this agreement can be evidenced by writing, or it can be implied by the court having regard to the circumstances of the case. We've also said that there is agency by estoppel, which confers what we call ostensible or apparent authority, in which case the principal has acted in a manner that causes third parties to believe that someone is their agent. And these third parties have gone ahead to deal with this someone as an agent, and their position has been altered as a result. Either they've parted with some monies or they have made some business decision having regard to that. In that case, the principal is estopped from coming back to say that the agent was not in fact his agent. The third category of agency relationships we said was agency by necessity or operation of law, in which case an agent is allowed to go outside of the scope of his authority when he's unable to reach his principal to obtain instructions on how to deal with emergencies. In that case, the law would provide protection for the agent by saying that he is deemed to have had such authority, particularly when his decision was meant to protect the interest of his principal. And then finally, there is agency by ratification. In that case, the agent did not have the authority to act, but after he had made the decision, the principal decides to ratify whatever it is that he has done and bear liability for his decisions or his actions. This is where we end today's video. I hope you enjoyed the session. See you again in another video. Bye.
Free audio post-production by alphonic.com.